Bob Bar represented the 7th District of Georgia in the U.S. House of Representatives from 1995 to 2003 and was the 2008 Libertarian Party nominee for President of the United States. He practices law with the offices of Edwin Marger and runs a consulting firm, Liberty Strategies, Inc., headquartered in Atlanta. Bob occupied the 21st Century Liberties Chair for Freedom and Privacy at the American Conservative Union and is currently a member of the Constitution Project's Initiative on Liberty and Security. He serves as a board member for Privacy International. Former New York Times columnist William Safire called him Mr. Privacy. Bob serves on the boards of directors for the National Rifle Association and One Force, a company providing domestic and international security. He was the chief prosecutor during the Bill Clinton impeachment trial. I could go on all day with his credentials and achievements, and I hope, Bob, you will forgive me for any number of things I have left out. It is my pleasure to welcome back to the Global Freedom Report, Bob Bar.
Brent, great to be with you once again. The only correction I would have is I'm no longer occupying the 21st Century Liberties Chair for Freedom and Privacy at the American Conservative Union. I was honored to do that until a couple of years ago.
Okay, well, excellent. I tell you, it sounds weird to say Bob. I want to say Congressman. What's the proper protocol to refer to you these days?
Either one is very proper, but calling a former member of Congress the same as a former president or a former senator by that title is entirely appropriate from a protocol standpoint. So it's not inappropriate at all to refer to me as Congressman, but certainly as friends. Bob is fine. So either way, Brent.
Great. Now, before we get into the real nut of what we're going to talk about, I just had a question, because as I was looking over some of your material, I was not aware that you had served on the board of One Force. Are you, by chance, in a position to shed any light on the degree of corruption that exists in the private security industry, with companies like Blackwater and now Z leading the way with its influence peddling antics and web of multiple corporations?
The problem, Brent, I think, is the manner in which our government has entered into agreements that insulate many of these companies from any sort of liability, which is, I think, inappropriate. It's not that there is inherently something wrong with utilizing private security companies to supplement the security needs of the State Department and other federal agencies operating in foreign lands. But Congress really needs to look much more carefully than they have in the past at the scope of the immunities and protections that are granted to some of these companies.
I have a soundbite that I took from an interview with you a while back in which you said Congress essentially has no backbone to do anything about these issues. Do you still feel that way?
They certainly haven't exhibited much in recent years. That's for sure. I am hoping that the incoming Congress, in which the Republican Party has regained the majority, will exercise and exhibit a great deal more interest in these issues and backbone in actually addressing problems than the past several Congresses have. And that goes for the particular topic du jour, the powers of TSA and how the American public is having their constitutional rights infringed by what the TSA is doing. I'm hoping the incoming Congress, beginning in January, will take a hard look and ask some very tough questions of TSA and actually amend federal law to rein in the agency.
And yeah, I want to talk about some specifics there. I have one more general question for you, if you will, Bob. You're about as staunch a privacy advocate as there can be in a country and world that has all but cast aside privacy. U.S. and UN officials have both said on numerous occasions that privacy is an outmoded concept in today's world in which terrorists have access to high tech. What do you say when you're faced with such an argument concerning personal privacy?
Privacy is the foundation of liberty itself, Brent. Our framers recognized that, and that's why they incorporated the notion of privacy, which is, in essence, the power of an individual to be free from outside control. That's the essence of privacy. Our framers understood that, and they incorporated that notion in ways that are apparent if one looks, for example, at many of the provisions in the Bill of Rights. The Fourth Amendment, most particularly, which protects us against unreasonable searches and seizures and requires that search warrants be founded on probable cause. That reflects the fundamental notion of privacy. The First Amendment as well, for example, that guarantees in essence the privacy of one's religious thoughts and religious practices and one's political beliefs is founded very clearly on the notion of privacy. Ayn Rand, Brent, had it right when she wrote in her great novel, The Fountainhead, back in 1943, I think it was, that privacy is the essence of civilization. It's the process of setting men free from the power and control of other men. And for people nowadays, Americans in particular, ought to know better. But for Americans nowadays to say, oh, we'll just give up our privacy for security, is discarding the very foundation of liberty itself.
And I would have to agree with everything that you have said there, and it leads us right into this discussion, because if privacy is not outmoded, if I have the right to privacy and I have certain Fourth Amendment protections, how is it that the moment that I enter an airport, suddenly this goes out the door? And I'm not only asking you in terms of your own personal viewpoints, but you were a congressman, so you were a lawmaker, and you were also a prosecutor, so you were an officer of the court. And the courts are backing all of this stuff, and what has happened to my Fourth Amendment when I enter an airport?
If you listen to John Pistole, the current head of TSA, you've surrendered your fundamental Fourth Amendment rights just because you have exercised your freedom to travel by air. The Supreme Court many years ago, Brent, as I'm sure you know, but some of your listeners may not, the Supreme Court many years ago declared very clearly that the right to travel, the freedom to travel, is a fundamental index of liberty, a fundamental component of liberty itself. Yet today, people have sort of fallen into this notion or this belief that we can only travel if by certain modes of transportation if the government gives us permission. That's absolute nonsense, and it's anathema to the very notion of liberty. If you take away a person's liberty or freedom to travel, you have taken away their liberty. You don't surrender your liberty simply because you choose to travel by air.
What you're saying makes such perfect sense, but what drives me crazy I'm sure you know all the stories. You know, we've been getting all these stories about the insanity going on, how people are being treated in the airports, and I have not heard of a single legal action addressing the question as to whether or not how it is that when I walk into an airport, suddenly the Constitution doesn't apply. Suddenly I have no Fourth Amendment protection.
These matters need to be addressed in the court, Brent, and they are going to be, at least in the near future. There are two court cases that have been filed, one by EPIC, the Electronic Privacy Information Center in Washington, D.C., led by a very strong privacy and advocate and constitutional scholar, Mark Rottenberg, and by the the Rutherford Institute by John Whitehead in Virginia. Both of those organizations have, within the last month, filed very strong challenges to the process and the procedures the TSA is implementing and operating under here. And both of those lawsuits have raised constitutional Fourth Amendment challenges to what TSA is doing, as well as other rulemaking and procedural challenges. So I think at long last we will, in the near future, start seeing some court decisions, and hopefully will result in a much clearer position that TSA cannot simply take away a person's Fourth Amendment rights and say the government has a right to subject you to a highly invasive and clearly unreasonable search simply because you've chosen to fly by air.
Now, let me pose a hypothetical situation. Okay, now, first, I am not a great believer that the courts are going to come and make a decisive decision because they almost always seem to leave wiggle room to get around it. But let's assume for the moment that we get a legal action, a court comes out and says, absolutely, the TSA cannot do this, not in the name of national security or anything like this. People have their basic rights. You cannot force them either through this potentially dangerous body scanner or force them to subject themselves to what you're doing. Okay. Now the president comes out, hypothetically, and says, based on the threat of terrorism, I'm issuing an executive order overriding that decision. Now, I know it's not supposed to happen, but in today's climate, I'm sure you would agree, it could happen. If such a thing occurred, what would be the recourse?